You know, whenever you watch a big trial, you see these expert witnesses, scientists, engineers, economists, testifying like they own the place. But have you ever stopped to think about how they actually got there? It's not automatic, not at all. There's this hidden high-stakes battle that goes on before the jury even walks into the room. And that is exactly what we're going to break down right now. I mean, listen to this quote. If your expert gets excluded, your case can collapse. Just think about that. This isn't some tiny legal detail we're talking about here. This is a single decision that can completely make or break a billion-dollar lawsuit or a criminal case where someone's life is on the line. The stakes, they're as high as they get. So, who holds all this power? Well, it's the judge. They act as this kind of gatekeeper. It's their job to decide which expert opinions are solid enough, reliable enough for a jury to even be allowed to hear them in the first place. And that really brings us to the big question, right? How does a judge make that call? What are the rules of the game here? Because it's not just a gut feeling. Nope. It's all based on two major and sometimes competing legal rule books that literally shape how justice works every single day. Okay, so this whole thing really boils down to two big competing ideas about how to handle expert testimony. And these two philosophies have been battling it out for about 100 years. It's a real clash of ideas about the right way to bring science into the courtroom. All right, let's break this down. On one side, you've got what's called the Frye standard. The easiest way to think about this one is as a popularity contest. All that really matters is the expert's method generally accepted by other experts in the field? But on the other side, you have the Daubert standard. This one turns the judge into a science fair judge. They can't just take the expert's word for it. They have to roll up their sleeves and actually dig into whether the testimony is reliable and if the method holds up. So let's look at Frye first. This is the old school rule, coming from a case way back in 1923. It's all about consensus. The only question the judge really has to ask is, has this scientific technique gained general acceptance in its field? Basically, is it popular with the other scientists? That's it. It's all about what the community of experts thinks. But then came Daubert. And this is the modern rule that's used in all federal courts and a lot of state courts too. And honestly, it changed everything. Now the judge can't just ask if an idea is popular. They have a duty, a responsibility to be that gatekeeper and make sure the testimony isn't just relevant, but that it's also reliable. And you gotta understand, this is a huge shift. Under Daubert, the judge basically has to put on a lab coat. They're being asked to evaluate the science behind an expert's opinion, to check their work before a jury ever gets a chance to hear it and maybe be swayed by some junk science. Now, this power didn't just appear out of nowhere. It was built up over time through three massive Supreme Court cases, often called the Daubert Trilogy. It started in '93 with the Daubert case itself, which set the whole gatekeeper idea in motion. Then in '97, the Joyner case made it much, much harder to challenge a judge's gatekeeping decision on appeal. And finally, in '99, the Kumo case expanded this gatekeeping duty to cover all kinds of expert testimony, not just the hard science, but also engineers, accountants, you name it. So how exactly does a judge play scientist? Well, they've got this flexible checklist of factors to consider. They'll ask things like, hey, can this theory actually be tested? Has it been peer-reviewed or published anywhere? What's the known error rate? Like, how often is it wrong? Are there standards for how it's used? And look at that last one. Is it generally accepted? See, the old Frye rule is still there. But now, it's just one piece of the puzzle. It doesn't get the final say anymore. And don't for a second think this is just some old, dusty legal rule that nobody thinks about. Oh no, this is an active, evolving area of the law. And this number, 2023, is a really big deal. Why? Because just recently, in December 2023, the federal rule on expert testimony got a major update. The new wording makes it absolutely crystal clear. The judge must decide if an expert's opinion is reliable enough to even get in the door. It shuts down this old lawyer's argument where they'd say, oh, just let it in, Your Honor, and the jury can decide how much weight to give it. Nope. The new rule says the judge has to make that call up front. This gives him even more power to kick out bad expert testimony. Okay, so now we know the rules of the road. Let's talk strategy. Because in the real world, lawyers use these Daubert rules like weapons. It becomes this high-stakes courtroom chess match, with each side trying to get the other's expert thrown out. So what does the attack look like? How you challenge an expert? Well, there are a few key moves. First, you can argue their whole methodology is just junk. Second, you can point out a huge analytical leap, where there's a giant gap between their data and their conclusion. Third, you can accuse them of cherry-picking data and ignoring anything that didn't fit their theory. And finally, and this is a big one, you can say, okay, maybe your method is fine in a lab, but you applied it completely wrong to the facts of this case. And of course, for every attack, there's a defense. So how do you protect your expert? Well, you basically do the complete opposite. You make sure their method is totally transparent. You show all your work, creating this clear, unbroken chain from the facts to the final conclusion. And this is crucial, your expert doesn't overreach. They don't claim more than their data supports. And the best defense, you preempt the attacks. You get out ahead of it and acknowledge any limitations or error rates yourself before the other side even gets a chance to. Look, I know this can sound like a bunch of legal inside baseball, but these gatekeeping decisions have massive real-world consequences. We're talking about rulings that can completely flip a case on its head and decide who wins and who loses. So where do you see these expert battles happening the most? Well, think about cases involving medical causation. Lawsuits trying to prove that something like lead paint caused a child's illness, or in complex accident reconstructions that rely on computer models. And the newest and maybe biggest battleground? Cases that involve AI and other complex digital evidence. In these areas, the judge's gatekeeping role is more important than ever. Let's dig into that a little. In those toxic tort cases, the whole fight is about that analytical gap. Can the expert reliably connect big scientific studies to this one person's specific injury? For accident simulations, the judge has to figure out if the inputs into that computer model are based on real facts from the case or if they're just pulled out of thin air. And with AI, the huge question is this a black box where we don't know how it got the answer, or is it a tool that's been validated and that an expert can actually explain? The judge's call on any of these can absolutely make or break the case. So what's the bottom line here? It's this. The next time you see some expert on TV or in the news making a big, bold claim, just pause for a second and ask yourself those Daubert questions. Can their work actually be tested? Did they apply it correctly to this situation? Because as we've just seen, the answer to those simple questions could be the very thing that the entire verdict hangs on.